What if I told you that every time a bank mails you a false statement or a collector emails you a bogus demand, they could be committing a federal felony? Today we're going to be exposing 18 USC 1341 and 1343, which pretty much talks about mail and wire fraud, okay? These are the statutes that govern mail and wire fraud, and essentially we're going to talk about how the banks use mail and wires to keep the debt game alive. Now, before we dive into this video, this is not legal, this is not financial advice. Remember to do your due diligence. Tap in and research these laws on your own. Number 2, hit the follow button, hit the subscribe button, like the video. You dig what I'm saying? If you do that and give me some energy, I can give that energy back to you guys. All right? So, right off the bat, what I want to talk about is the criminal acts. And I'm really doing a series right now talking about the criminal side of private banking, how banks are actually criminals. So if you're discharging debt, if you are doing it any type of private banking, or if you're exercising your right as a creditor, ultimately, some people think that this is a immoral thing, or you can't do this, or it just seems obscene. But the reality is the fact that they're doing obscene things to you. Matter of fact, it's illegal what they are doing. Okay? So right off the bat, man, we can go to 18 USC 1341, and it talks about mail fraud, okay? Specifically talking about fraud and swindles. It says, whoever, having devised or intended to devise any scheme or artifice to defraud for obtaining money, property by means of false and fraudulent pretenses, representation, or promises, or to sell, dispose, loan, exchange, alter, give away, distribute, supply, or furnish, or procure for unlawful use of any counterfeit or spurious coin, obligation, security, or other article, or anything represented to be or imitated or held out to be such counterfeit or spurious article for the purpose of executing such scheme or artifice, or attempting so to do, places in any post office or authorized depository for mail matter, any matter or thing whatever to be sent or delivered by the postal service, or deposits or causes to be deposits in any matter or thing whatever to be sent or delivered by any private or commercial interstate carrier, or takes or receives therefrom any such or thing, blah, 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 blah. It just gets worse and worse as I read it. You dig what I'm saying? And can you picture, these are some of the things that the banks are doing to you, okay? Some level of scheme, some level of artifice, okay? So it is a crime to use the U.S. Postal Service to send any scheme or fraudulent representation. So if they lie in their mail, okay? If they send you a bill that is giving me the idea that I have to pay it under false pretenses, that right there could be considered mail fraud, which is a criminal charge. It says, such person shall be fined not more than $1 million or in prison not more than 30 years or both. You dig what I'm saying? So you could be fined up to $1 million and acquire 30 years maximum in jail for doing mail fraud. Now this goes for both parties, okay? Whether you are a natural person or you are a business or the bank. It goes for both sides. So you don't want to participate in this because you could be in prison. But also at the same time, vice versa, they participate in it, but because they know the game so well and nobody calls them out on their mail fraud, this is why they're able to do it. Because somebody may look at this and say, well, it's a criminal offense. Well, why is there nobody stopping it? Well, why would they? The people that are supposed to stop it is the person that is receiving the harm. Not there's Batman. Batman is sitting here being a vigilante and, you know what I mean, like waiting for something bad to happen to you and come swoop in and save you. No, if somebody does something to you, you call them out, you hold them accountable, you do something back to them. So then we dive into, all we got to do is click next. And now we're at 18 USC 1343. And for those of you guys who want to know exactly where I'm at, if you were to go to the Constitution or you were to law at Cornell, it's in Title 18, Part 1, Chapter 63. And Chapter 63 pretty much breaks down mail fraud and other fraud offenses. So if you wanted to learn more about fraud isn't just for people. It's for corporations as well, companies as well, okay? So you got all of this, even bank fraud. And I'll do a separate video on bank fraud. I want to just talk about some of the stuff that we see, okay? Whoever having devised or intending to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, representation, or promises, transmits or causes to be transmitted by of a wire, radio, television communication, or interstate or foreign commerce, any writing, signs, signatures, pictures. This goes for emails. This goes for, actual mail, right? Shall be fined under this title or in prison not more than 20 years or both. If the violation occurs in relation to or involving any benefit authorized, transported, transmitted, disbursed, paid in connection with a presidentially declared major disaster or emergency, or an effects of a financial institution is up to 30 years, okay? So it's essentially the same as 1341, but for electronic communications, faxes, texts, credit, bureau data transmission. And if they were to put any inaccurate data on your credit report, unverified data on your credit report, it technically can fall under the category of fraud, okay? Each email, each credit report entry, each electronic notice equal a separate potential felony. So if you ever gotten an email, right, you have reached out, you sent a letter to the company, and then the company decides to send you an email of their response. You know that their email has nothing to do with the letter that you sent them. And I've even heard that there are attorneys that will send you emails lying, or even a customer representative lying about, maybe because they don't know, but they are a part or an extension of the company. So if you don't know that you are lying, and it is a lie because of what I know, then that right there falls under the category of fraud. Because why would you put somebody in position to communicate with me who doesn't know the law? Okay, that's number one. And number two, when I explicitly ask for somebody who does know the law to be able to talk to me about this, why would you send a customer service representative or some consumer agency, or not agency, but your consumer rights department to reach out to me and they know nothing about the law? So when they start lying, whether it's an email, whether it's over the phone, right? If there is recording or proof that they have done this in email, you can tell them, listen, this email itself, because I know that you are lying, this can fall under the category of wire fraud, okay? That is punishable more than 30 years in prison, okay? So it's no use of you lying to me. And then we can dive into the Truth in Lending Act and talk about all the other ways that their lies can also cause harm to the business. So again, I need to speak to somebody that's serious and isn't going to just make up stuff because they're just doing their job. No, I don't want you to just do your job. I want you to communicate and negotiate with me, okay? Or give me somebody that can, all right? So every false billing statement, every robo letter, every email from a collector without proof could be a federal offense. Now I say could and not is because it's up to you to be able to prove that they are attempting to defraud you. Okay. Now, let's talk about how banks and collectors commit mail fraud and wire fraud daily. Okay. Number one, debt validation evasion. They keep mailing statements after you demand validation under 15 USC 6092G. Under 15 USC 6092G, you have the ability to validate debt. Okay. But they would evade that. They will ignore these validation attempts and continue to send you letters attempting to collect on a debt, or will say, oh, well, you can't do that. Just pay. Okay. And then eventually they'll try to get you to agree to pay. This right here can fall under the category of mail and wire fraud. They're doing it via the mails, then it's mail fraud. They're doing it via email, wire fraud. Okay. Credit reporting fraud. Banks and servicers transmit false data to Equifax, Experian, and TransUnion electronically. That transmission equals wire fraud if they know it's unverified. So again, if you challenge the credit bureau on data and tell them to verify data on your credit report and they do not do that, that right there can fall under the category of credit reporting fraud, which is also a form of wire fraud. Okay. So right after the credit reporting fraud, we can dive into the securitization trick. We talk about securitization, understanding that your loan agreements are actually bonds that are monetized by the banks. They securitize it. That's what that process is called. When people are trying to understand what is happening behind the scenes as it pertains to banks and why we are able to discharge, is literally because they're able to make money off of the original loan agreement. And I'll just keep repeating this because new people come in and out of these videos. But because the note has already been sold or securitized, let's just say they attempt to foreclose on you and send like a foreclosure notice. Let's just say that they are attempting to collect on the debt and they don't even legally own the debt. They've sold it off to somebody else. The only person that should be reaching out to you about debt is the person who owns the note. Now, if you sold it and made money on it, then you aren't the legal holder in due course. You could potentially be a servicer, but you aren't the legal holder in due course. Okay? So anything after securitization can easily, I won't just say easily, right? You still have to be able to prove this and be able to substantiate it, but it can fall under the category of mail fraud, okay? Form letters and robo-signing, okay? Mass-produced affidavits, boilerplate letters, right? Letters that are supposed to get you scared, big warning signs, a dunning notice sent through USPS. And if they lack factual basis, each piece is a fraudulent mailing. Now, one letter alone is fraud. And it's important to know because under 18 USC 1961, USC 1961 breaks down what racketeering activity is, okay? So under this, it says if you show a pattern of mail and wire fraud, 2 or more acts within the last 10 years, 2 or more acts within the last 10 years, you can argue that it's organized racketeering, okay? Banks and collectors send hundreds of letters and emails and transmissions daily, and that pattern equals exactly what Congress envisioned when it drafted a RICO, okay? So a bank could potentially be for a RICO charge. And you guys think it's about drugs, but no, it's about organized crime, okay? Organized fraud, okay? So this is how you can escalate from a bad debt collection to a federal racketeering behavior. And when you start to do this, a lot of people will say, well, why would you bring this up? I mean, obviously, if you're trying to drive the point of why you shouldn't pay a certain company, saying that they could potentially be criminals can really open up the floodgates. I mean, think about it. Okay, that's bad publicity. That's bad press. All right. And again, you want to throw the whole kitchen sink at them because you want them to settle. You want them to reach out to you and be like, damn, this person really does have a case, is able to prove it, substantiate it. God dang. Let me go ahead and do what I got to do. Okay. So yes, we are talking about debts and banks and things of that nature, but you can truly start to add these other codes and laws to really escalate and drive your point as to why you decided to stop paying and use this other route. You know what I mean? Of discharging. All right. Because I'm not going to pay into some racketeering bullshit. You dig what I'm saying? So here's the proof you need. Okay. And here's how to properly document it. All right. Number 1, you want to save every envelope, letter, and statement. Certified mail receipts are gold because it'll show that you have sent mail, they have received the mail, okay? And the time that it was sent and it was received. Number 2, you want to screenshot every email, every credit report, or online account message, all right? You want to log phone calls if they're referencing false balances, right? Wire fraud includes telephonic, okay? So you want to log the phone calls. You can record it, but you have to be very strategic about the recording because technically, unless you say that you are recording, then technically you can't record them, but obviously ask that. But if there's some fraudulent things going on, then you need to have evidence of that. I wouldn't tell you to not record it even if they tell you not to, okay? You can keep disputes and responses showing you told them the info was false, but they mailed it and emailed it anyway. See, this is what I tell people. When you get a letter saying that what you are doing are fraudulent, or they attempt to say something that, I had a client that talked to me about, she was arguing with the attorney about charge off and written off, as if it doesn't mean the same exact thing. Okay? So because it wasn't written off and it was charged off, that means that you can come after me for the debt. No, that doesn't make any sense at all. I can clearly show you where charge off means that after you continue to collect on the debt, it becomes unjust enrichment, because if it was charged off, that means that it is settled. So you just revealed to me that it's charged off, right? So what are you telling me to pay if it's already charged off? You just gave me the proof within itself. And sometimes they'll play the semantic game and go back and forth with you and argue with you about something that has nothing to do with the matter at hand. Okay? Or they'll just knowingly give you false information and say you can't do that with no real information behind it on falsity, if that's a word. If they mail or email you lies, this can fall under, this is also evidence as well. And call them out. Hey, look, if you mail me a lie, you know that would be considered wire fraud. Okay? This is why I need you to write it too. Okay? I want you to also send it an email, but I want you to take this email and I want you to write it to me in written form. Okay? Because I'm going to expose, if you are so confident in your response to me, write it down and send it to me. Because I'm going to hold you up to that. I'm going to claim this to be wire fraud or mail fraud because of the lies that you're saying in here. You're essentially saying that you never securitized it, but you can't prove it to me. So in my affidavit of truth, I'm going to put that, hey, I asked for a proof of securitization, or proof that they didn't securitize it, and they decided not to give me the proof. They said they didn't have to give me the proof, but I can go to the GAAP. I can go to, I can ask for a qualified written request under RESPA. I can ask for information under UCC Article 9. If you lie and say that UCC Article 9 doesn't apply to you, that will be a lie. That can fall under extortion, okay? More mail and wire fraud, misrepresentation and lies, for which he is required to give. If you and I are doing business together, I should know any and everything about whatever it is that I am doing. Okay? So, your evidence is super key when you are communicating with debt collectors, because that will show the courts a pattern. Once you've got multiple fraudulent communications, and I say multiple, you've built the backbone of mail and wire fraud. Now, again, this doesn't have to be your primary angle, but throwing that in your communication with them now gets them to thinking, okay, dang, this person's now talking about some criminal activity that I'm doing. Now it's more work for my attorney to do, more money that I have to pay my attorney to overcome this, because now I have to prove that I didn't do any mail fraud or whatever the case may be, which they can't prove if they literally sent you a lie of a letter, thinking that you don't know 18 USC 1961 or 18 USC 1343. Okay? Now, here's how to use this against them, all right? Now, obviously, we're at the point of the video where this is the whole purpose of what I'm talking about, okay? The reason why you want to learn these laws, even on the criminal side, and I'll continue to make more videos on this, but you want to learn this because the whole point is to have leverage against them, okay? If you have civil leverage using the criminal law to your advantage, this can help escalate the civil aspect of it, because once you start to raise mail and wire fraud and arbitration or court filings, these are actual acts that can potentially land them in jail. Okay, and when you combine this with the FDCPA and the FCRA and the provisions under the Truth in Lending Act, it will strengthen your case. So it's going to give you leverage. Number 2, regulatory complaints. File complaints with the CFPB, the FTC, and the State Attorney General citing mail and wire fraud language, because it forces regulators to pay attention. Again, regulators can only do so much, but they can be able to add a paper trail or maybe able to push the company to respond much faster, okay? Much more clear, not ignore, you know? Number 3, criminal referrals. You can send evidence packets to the U.S. Attorney's Office or the DOJ, the criminal division. While individuals rarely get indictments alone, the threat of a federal investigation is powerful leverage, all right? Because if you send this and you show record of you sending this to them, then it's like, damn, all right, they got the DOJ involved, the U.S. Attorney's Office, they filed with the CFPB, right? And they have evidence of me actually committing these acts? Shit, I don't want this to go any deeper. You want to throw the whole kitchen sink at them. I don't know why we want to kind of shortchange it and want to just send one little gold check, one little letter, one little coupon, one little remittance, one little 1090, fill out a 1099 form and our debt be wiped away. No, this is a full battle, okay? Do you know that the attorneys can literally could see someone visibly, you know what I mean, like shoot somebody, but unless they can prove it, some of these cases may take months, maybe even years for them to be able to prove that, you know what I mean, for them to close out a case of a killing, you know what I mean? Because if the opposite side is a good lawyer, okay, did a good job of covering up the evidence, all right, been getting away with it, more likely they know how to operate through these situations, okay? But even in those cases, you have to be able to provide evidence against someone that you claim killed someone. So vice versa. We're talking about debts and things of that nature, and you think that they're not going to try to shortchange you, or you think they're not going to try to fight back or debate. If you're saying that I'm doing something fraudulent, I need you to prove it, because I don't take that lightly. Okay. Also, bringing this up also is a weapon for discovery. Okay. In court, demand all communications that they send. Okay. And if they can't prove that the statements were accurate, you have highlighted fraudulent mailings. You can ask in court, hey, look, the reason why I'm here today is because I'm demanding for them to send me the documentary evidence that have to do with my contract, because they send me collection letters and I want them to validate the debts. I also want them to send me the accounting from the account. I also want them to provide proof that they didn't securitize it, because I know they did. That is what I believe. Okay, that is what I know. And you can ask me, do I have proof? No. You guys show me the proof that you guys didn't securitize it, that you guys are even a legal holder in due course. So let's shift the conversation from securitizing and tell me if you're the legal holder in due course by pulling up the chain of assignment. That's what I'm going to court for the information that I asked for. Okay, if they give me the information, then the charges are dropped. But if they can't, I'm gonna have to, because all of this harm that they've done to me over this extended period of time. Okay, so let's bust some of the myths. All right, number one, it's just a bill, not fraud. The truth is, if it's knowingly false or unvalidated, it fits the statute 18 USC 1341. Okay, wire fraud is only for hackers. The truth is, transmitting false debt data electronically is wire fraud. So if you get a debt collection letter in your email and you think that is something that is false, that can be considered wire fraud unless it is proven otherwise. And then myth 3, the courts won't apply this to the banks. The truth is, banks have been fined billions under mail and wire fraud theories, and the difference is whether you raise it. So you have to bring it up in question, okay? Still have a solid argument on the debt side, but also at the same time have a solid argument and include things like criminal acts, criminal statutes. Okay, now here's the big picture. Every envelope, every email, every data transmission is potential evidence of fraud. Okay, banks thrive because people don't recognize it as criminal acts. They think it's just paperwork. But once you know this, you realize the same laws that take down scam artists apply to banks too. So mail and wire fraud is the Achilles heel to banks. Okay, now, so the next time the bank mails you a statement that they can't validate, remember, that's not a nuisance. That could be a federal felony. And when you see the pattern, you see racketeering. This is how you shift from being the debtor to holding them accountable under the very laws that they hope you never learn. So if you want me to break down how to build a case with mail and wire fraud evidence, comment the word fraud down below and connect with me inside the Fund Yourself Academy. It's only $27 a month. You can get in there for free for 7 days. Okay. Number 2, if you want to work with me one-on-one or get a one-on-one call set up with me, down below, go ahead and hit that application. The application is right under the school community. Tap in and speak with either me or my team. Number 3, hit the follow button, hit the like button, hit the subscribe button, turn on the post notifications. All right. And lastly, I wanted to talk about this at the end, but for the other people that want to also work with me and do what I do, and what I mean by do what I do is build your own personal brand and make money off of your passions and make money off of your skill sets, also hit that application button, but it's only for serious people only. This is a premium coaching experience, so it's not going to be something that's going to be like, it's not going to be a couple $100. Okay, I'll just put it to you like that. All right. Thank you guys for tapping into the community. Thank you guys for tapping into my video. I love you guys, and I'll see you in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.